There is a number in a federal docket that the current president of the United States has not been able to erase. $83,300,000. Two juries found it. 3 appeals confirmed it. And on April 29th, the United States Court of Appeals for the Second Circuit, sitting at full strength, declined to disturb a single dollar of it. But that is not the part of the story I keep returning to. The part I keep returning to is what Trump's legal team attempted 15 months after losing that verdict. Because what they asked of that court has never been tried in American legal history. And the question it raised is now sitting in front of 9 Supreme Court justices who have never answered it either. Let me explain the mechanics, because they are the entire story. The case is E. Jean Carroll versus Donald J. Trump. In 2019, Carroll published an account of being sexually assaulted by Trump in a Bergdorf Goodman dressing room in the mid-1990s. Trump denied it for years. He said he had never met her. He said she was not his type. There is a photograph from 1987 showing them together at a charity event. The denials continued anyway. 2 separate cases went to trial. The first, in May of 2023, resulted in a federal jury finding Trump liable for sexual abuse and defamation, $5 million. The jury deliberated for less than 3 hours. The second trial, in January of 2024, focused on defamation alone, specifically the statements Trump kept making about Carroll after losing the first case. 3 hours of deliberation, $83.3 million. Broken down, $7.3 million in emotional damages, $11 million in reputational damages, $65 million in punitive damages. Punitive damages are not compensation, they are a message. $65 million is a jury telling a defendant that ordinary damages are not sufficient deterrence. They looked at the record of continued public statements made after a federal court had already found him liable and decided the number had to be large enough to matter. He kept making the statements anyway. Now here is where the legal story takes the turn I cannot stop thinking about. 15 months after that $83 million verdict, Trump's legal team filed a motion arguing the defamatory statements were not made in a personal capacity. They were, the argument went, made in his official capacity as president. And under a federal law called the Westfall Act, when a federal employee causes harm within the scope of their employment, the United States government can be substituted as the defendant. If that substitution had succeeded, the consequences were mechanical. The federal government holds sovereign immunity from defamation claims. Substituting the United States as defendant would have automatically erased every dollar of the judgment. Carroll would have collected nothing. And the liability for statements made about a private citizen from a presidential podium would have transferred to American taxpayers. That is not a hypothetical. That is what was actually asked of the court. The Second Circuit said no. A 3-judge panel said no last September. Then Trump's team filed for en banc rehearing, asking every active judge on the circuit to reconsider together. The full bench convened. The majority denied the motion. Judge Denny Chin, who wrote the majority opinion, used 34 pages to explain why. He noted that no ordinary defendant would be permitted to walk into court 15 months after losing a trial and ask the government to absorb the judgment. The timing alone was disqualifying, but the story does not end with the denial. The dissent was 54 pages long. 3 judges, led by Judge Stephen Menashe, wrote that the case represents a significant legal development the full circuit should have reheard. Their argument was that the Supreme Court's 2024 ruling on presidential immunity created constitutional questions the Second Circuit's existing case law had not resolved. They would have granted the rehearing. They would have examined whether Trump's statements about Carroll, made from an official platform during his first term, constituted official presidential conduct under the immunity framework the Supreme Court had recently expanded. That document is not just a minority opinion, it is ammunition. It is precisely what Trump's lawyers needed to demonstrate to the Supreme Court that a genuine circuit-level conflict exists worth resolving. A 54-page dissent from judges of that seniority on a question of that constitutional weight functions as a formal signal to the justices in Washington. Within hours of the ruling, Trump's legal team released a statement announcing the appeal would proceed to the Supreme Court. They also made a claim worth examining carefully. They said the Attorney General has determined that the Department of Justice is legally required to take over the defense. That is a statement from the president's private legal operation, asserting that the executive branch's own law enforcement apparatus is obligated to absorb the liability from a civil defamation verdict. Whether that position has any legal foundation is unresolved. But if the Department of Justice formally moves to substitute at the Supreme Court level, the implication is significant. The government's official position would be that presidential statements about private citizens, statements two juries found defamatory and made with actual malice, constitute official acts of the presidency protected by immunity. That question has no precedent in American law. Richard Nixon faced civil litigation but did not ask the government to pay his bills. Bill Clinton settled the Paula Jones case out of his own pocket. No sitting president has previously attempted to use the presidential immunity doctrine to eliminate a civil defamation judgment for conduct two juries found unlawful. The Supreme Court's 2024 immunity ruling addressed criminal prosecution of a former president. Whether that logic extends to private civil judgments against a sitting one is entirely open. There are two Carroll petitions in front of the justices. The first involves the $5 million verdict and evidentiary questions from the first trial. The second will follow the en-banc denial and center directly on the Westfall Act substitution. The Supreme Court has not indicated whether it will hear either one. If the justices grant certiorari, they face questions the American legal system has never answered. How far does presidential immunity extend into civil cases involving private citizens? Does it cover statements made from an official platform about conduct predating the presidency? Does it survive two jury verdicts finding actual malice? And can a sitting president direct the Department of Justice to absorb a personal civil judgment and charge it to taxpayers? If the justices decline both petitions, enforcement begins. Liens, asset attachments, the full civil collection machinery applied to a sitting president. There are no established procedures for that, no case law, just the judgment and the legal right to pursue it. What is already permanent, regardless of what happens next, is the record. Two juries examined the evidence and reached the same conclusion. The Second Circuit affirmed, the record in the Southern District of New York is permanent. The Supreme Court can narrow the immunity question or expand it. It cannot change what 12 jurors decided on two separate occasions. The maneuver attempted here, shifting $83 million of personal civil liability onto American taxpayers using a federal employment statute, was denied at every level of the federal appeals process. The constitutional question it raised has not been resolved. 9 justices will now decide whether to answer it. Until they do, the verdict stands. The court said no.